Call to order the meeting of the Cherry Hills Village City Council for Tuesday, September 1st, 2020. And could we have a roll call, please?
Councillor Safavi?
Here.
Councillor Wheel?
Happy to be here.
Councillor Brown? Here. Councillor Gallagher?
Here.
Councillor Sheldon?
Here.
Councillor Blum?
Here.
Shows that all councilors are present and Councillor Sheldon by Zoom. We'll stand now for the Pledge of Allegiance, please. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, first item up would be audience participation. And Laura, if you could. Oh, that's canceled.
Hello.
Mayor, if you'd prefer, you could take virtual participation first while everyone gets signed up.
Yes, yeah, Rob's online. Did you? I'm sorry, Emily.
It's just Rob Eber on for virtual.
Hello, if you're waiting for me,
Or
this is
whichever.
Robert Eber. It's very hard to hear you all.
Okay, and Rob, we haven't started yet, so can you hear us now? Rob?
Yeah, Mayor, it's Dan Sheldon. I will tell you, and I know this is not an ideal scenario for people to be calling in, especially in the day of masks, but it is super hard to hear and understand and make out what everyone's saying. So I'd ask that if you could, loud and directly into the microphone. If you're comfortable taking your mask down during speaking, if that's not something we want to do, that's fine. But I'm making out about 3/4 of what is being discussed.
Okay, thanks, Dan. Can you how about now? Can you hear me?
Better, thank you.
And Rob, can you hear us?
Rob, if you could unmute yourself.
Okay.
Good evening, Mr. Mayor. Good evening, members of City Council.
Thank you, Rob. Would you like to go ahead, Rob?
Go ahead. Are you ready?
Yes, we're ready for you.
I apologize for having some technological issues. Mr. Mayor, members of City Council, my name is Robert Eber. I live at 3 Middle Road. I was unable to attend our last PTRC meeting when an issue that you have on tonight's agenda was addressed, that involving the Skolnick family and a revocable license or a license agreement that may be at issue as one of the agenda items for tonight, is my understanding. I understand that the property owner seeks to use a public trail for a private purpose of getting feed and supplies for a barn as well as for emergency access. PTRC.
Rob? Rob, can you hear us? It's frozen. Why don't we go? Let's go on to the public here, and then we'll see if we can get Rob back on the line. So first name, sign up, Jay Skolnick. I hope I got the name correctly. If you'd like to approach the podium, please.
Good evening, I'm Jay Skolnick. Thanks for having me here. We moved to our house in about 2006, and our attraction to the area was really because You know, we like horses and the outdoors.
Something,
Mr.
Chris?
Mayor, if you're here to speak about the request for the trail, that's actually on the agenda later in the evening.
But there's no public hearing. It's,
Well, that's true, but I didn't know if you were going to allow.
no, well, if you'd like, you're welcome to speak now, and that's fine, but we'll be
Or-
discussing this later.
Yeah, I can come back after you make your presentation.
What's the pleasure of council?
Perhaps if anyone else wants to speak at that time, let's do it together.
Right.
Be easier as a package. Yeah.
Is there, and I think that we have, actually, everybody who signed up here, there's 5 people to sign up during that. We can take you up during that, when that issue comes up before us, which won't be long, it's coming up
Yeah,
pretty quickly.
Okay.
Is there anybody here wanting to speak about something other than the bridle path? All right, any reports from city boards, commissioners, or committees today? Hearing none, let's go and move on to agenda item 7.
If
Rob
I
is
could,
back with us.
okay, if I could request just to remove item 7C.
Okay.
But then I would move to approve consent agenda items 7A, B, and D.
Second?
I have a motion, a second, all in favor of A, B, and D?
Aye.
Aye.
Counselor Brown, then? you
And
can
then
speak
for
to
7C, there's no controversy. I just thought that Ms. Cooper, who is a resident artist, is making a very generous donation of a piece of art to the city. And I wanted to take the opportunity to publicly acknowledge that in the meeting minutes and not have it kind of go unsaid through the consent agenda. So I just wanted to express, it's a beautiful piece of art. It's hanging out in the hall. She's been a longtime resident of Cherry Hills Village. And we're so appreciative of her generosity in donating that piece to the city. So thank you, Ms. Cooper, if you're watching. That's all. So I now move to approve consent agenda item 7C.
10C. Oh, no, 7C, sorry. Motion, a second, all in favor?
Aye.
Aye. Approved. Passes unanimously. On now to a new business, agenda item 10A. And Emily, will you be presenting?
Good evening, Mayor and members of council. In 2013, former city manager Patterson signed a 1-year revocable license agreement with Jay and Cheryl Skolnick. This agreement granted vehicular access to a bridle trail to care for horses on their property. The Skolnicks have recently submitted a letter requesting a new revocable license. To provide some background, the Skolnicks reside at 1635 East Layton Drive. A map is up on your screens. The back section of the property is accessible by crossing a footbridge across Little Dry Creek. And the Skolnicks have legal access off of East Layton Drive. One of the city's bridle trails, Trail 2047, is located behind the Skolnick property. The easement for this bridle trail was dedicated and accepted by the city as part of the Cherry Hills Estates subdivision in 1977. In 2012, the city issued a building permit to the Skolnicks to construct a barn on the back section of their property. The barn was completed in April 2013. Later that year, the Skolnicks approached the city to request vehicle access to the bridle trail behind their property to care for horses in the new barn. In August 2013, the city sent a certified letter to the Skolnicks allowing temporary vehicle access to the trail twice per month until November 1st, 2013. As outlined in the letter, the purpose was to allow the homeowner time to construct a new bridge across Little Dry Creek or find an alternative solution to access the back of their property. On October 29, 2013, former city manager Patterson signed the personal revocable license agreement to allow the Skolnicks twice monthly access to the trail. It stipulated the Skolnicks should contact the city to unlock the bollard at Huntwick Lane for vehicle access to the trail. The agreement was limited to a year and expired on October 29, 2014. Between 2014 and 2019, the city didn't receive a request to renew the license agreement or a request to unlock the bollard at Huntwick Lane. For context, under the municipal code, No motorized vehicles besides public utility vehicles or emergency vehicles are permitted on any of the bridle trails. If vehicle access to a trail is necessary for utility work, we issue a right-of-way permit that is time limited. Revocable licenses are not usually granted for trail access, and we aren't aware of any similar licenses with other homeowners. Vehicle access to trails is physically prevented through the use of locked bollards at trail entrances that have to be unlocked by city staff and removed from the ground to allow room for a vehicle to pass. This issue came to staff's attention this February when we received a request to remove the bollard at Huntwick since the bollard had frozen into the ground. Staff removed the bollard at that time, but we advised the property owners that their agreement had expired and a new request would be necessary for future access to the trail. Staff noted an eye bolt had been pried open so the chain on the bollard could be removed without undoing the lock. Staff replaced the lock system at that point. In May, we received another request to remove the bollard. We again advised that the agreement was expired, and this time we did not unlock the bollard in response to the request. Following that request, the city received complaints related to the horse activities at 1635 East Layton, including increased traffic and trash in the neighborhood, and that hay trucks for that property drove onto a neighbor's property. In July, code enforcement responded to a complaint regarding private vehicles driving on the bridle trail and parking on an adjacent homeowner's property again. Code enforcement spoke with the boarder and the owner. Due to the complaint, park staff visited the trail as well. Staff observed that the lock chain on the bollard had been cut, making it possible again for the bollard to be removed for that vehicle to enter. The Skolnicks have now submitted a letter of request for a new agreement. Staff has concerns about permitting regular private vehicle access that may create conflict with pedestrians, cyclists, or equestrians using the trails. We have additional reservations about setting a precedent for regular private vehicle access to for using public trails to access private property. Staff does not recommend granting a new revocable license for vehicular use of a bridle trail. PTRC also considered this issue at their August meeting. The original letter from the city to the Skolnicks wasn't available at that time, but Deputy City Manager Goldie noted that the original intent of the revocable license was to provide temporary access to allow the applicant to make other arrangements. PTRC recommended to City Council that the city enter into a new agreement with the same stipulations as the 2013 agreement, with the caveat that staff determine the cost to the city for allowing access. Based on the Commission's recommendation, staff has prepared approximate costs, and those were included in your packets. Two motions are also included in the packets to either deny the request or to direct staff to create a new agreement for consideration at a future council meeting. I'm happy to answer any questions.
Okay, I'll go on council, and council questions for staff now. Councilor Blum, questions for staff. Councilor Gallagher. Councilor Brown. Councilor Wheel. Councilor Savabi.
No question.
We'll hear from the public. Oh, Councilor Sheldon, sorry. Any questions? Councilor Sheldon.
Just, do we know when the lock was cut after July 7th inspection?
It would have been cut before July 7th, but we don't have a specific date for when. Park staff went out to check the lock because of the code enforcement complaint, and that's when they observed it at that date.
Okay, and the operation of motor vehicles pursuant to our code includes installing, maintaining, or servicing parks or trails or a utility such as water, sewer, or gas line, or telephone or electric power line or installation. Would we have missed something else in there? I'm sorry. Is that an all-inclusive section 11.3/80? Is that an excerpt straight out of there?
Yeah, that's the entire section.
Yes.
Okay, no other questions. Thank you.
Okay, no more questions. Council, I'll take comments from the public then in order to time. Mr. Jay Slotnick, please. Approach and speak. You're welcome. Yeah, if you'd like to hand it to.
just handing a copy of the plat that was recorded in 1977.
Could you state your name and your address?
I'm Jay Skolnick. I live at 1635 East Layton Drive, Cherry Hills Village. In 1977, the plat was recorded, and the land was never dedicated in the sense of giving up the land. And, you know, you do have dedications for roads. You give up the road. But this was a dedication of an easement, not a dedication of a piece of land. And that's very important because we actually own the bridle path. We pay taxes on it. If you look at the plat that I'm handing out, the green stripe is our land. That is the bridle path. There's a 16-foot bridle path there. But we have given an easement. Our neighbors gave an easement through the recording of the plat. Therefore, we have reciprocal easement rights that would take us all the way to Huntwick. We also have prescriptive rights because the easement is already, you know, is open and has been open for easy use. So we have reciprocal rights, we have prescriptive rights, we also have property rights because that is our land. Your neighbor that complained about maybe a hay truck should understand that we own the land. If you're on that path, it goes up a little to the neighbors to the east. If you look closely, there's pedestals there, electrical pedestals. That's actually the property line. So if they were to make a turn into our land, they're not driving on their property, they're driving on ours. There's actually some stakes. If you go down towards like the swing set, further towards Woody Hollow, you can sometimes see a couple stakes there where the property lines were. Surprisingly, they're actually up the hill towards those homes on the east. So sometimes neighbors speak out of school and don't realize where the property line is. I think our sprinklers are maybe within our property line. So all we're asking for is really our property rights, but you know, when you sort of look at the whole picture from 30,000 feet, we're really just asking to have the ability to take care of the horses, feed them, and stay in the spirit of the city. The city wants, you know, we moved here because we like the rural community, the horses, the lifestyle of, you know, just having horses. And that's why we built our barn, and that's why my wife brings her horse, you know, to retire at the house. So, and, you know, we have Woody Hollow and all these other great amenities. But trust me, if we could go from the front of our house, we would. But there's a 25-30% slope. There's a creek. You know, in those minutes from before, it talked about paving. That wasn't us. Someone else maybe had a flatter area where they could, you know, make a access. But we have absolutely no access over our bridge. But all we're really doing is looking at, you know, I believe your code, by the way, for motorized vehicles was, you know, it's worth checking, but we were recorded in 1977, our plat, and I think it was after that, so we would be grandfathered in. But besides that, it's just the spirit of the city. It would just be odd to live in a city that wouldn't allow people to take care of their horses, especially when we do know there's other people that have double locks around the city where, you know, the neighbor can use the second lock and not touch the city's lock. All we're asking for is access for hay, you know, a farrier periodically for shoeing, but the, you know, the farrier is a lot less active in the winter, and the and then of course emergencies, like our neighbors had to call a doctor for their animal. So, you know, there's practical purposes, but, you know, granted, you know, even this fee, it's sort of pathetic because we could drag the hay in, let's say on a wagon or something. Let's talk about non-motorized vehicles. Maybe we could somehow get a non-motorized vehicle. He'd have to open the ballot for us. It's our right to get into our property. So that's sort of, that was petty, but I think it was, maybe they just wanted to prove a point. You know, I can't understand why they went to the exercise. But we probably do need a motorized vehicle because the hay is heavy and you usually get the hay. We want to reduce the traffic, so we want to get hay as little as, infrequently as possible. So you stack the hay up in the truck, you get in and out, and then you leave. That's the idea. So, that's, it's just a practical situation of, unfortunately, our lot happens to be, almost landlocked, but it's not because we have the bridle path, which is really our land. I don't think a lot of people realize that dedication, it was dedication of an easement, not dedication of a piece of land. You could easily have had a bridle path through a true dedication of land, but we actually are paying taxes on that land. And you can see it's inside the bold line. If you look at the line there, that bridle path's inside our lot. So, it's really our land that we're just using. And that's sort of the whole, I don't know if I missed anything, but do you have any questions?
I don't think so. Thank you very much
Okay.
for coming tonight. And Cheryl, would you like to speak to?
Just a couple of things. I'm a veterinarian, so I know the importance of taking care of animals, especially in time of 2 a.m. in the morning when one of the horses colic, or Melissa Miners here, one of her pigs was really sick. We had to get into a car to get to the veterinarian. I mean, I understand calling 911 is definitely an option, but having a key, I know that the lawn people over at, I think it's Terryville by the Woody Hollow, there's 2 keys. It gets locked by the city, and there's also a second key. I mean, having access with a key keeps other people, motorized vehicles, other than who absolutely need it in the middle of the night, to use it. So I think that's important aspect of, not only just granting us the motorized vehicle issue, but also just granting us a key that we do have access 24/7. So that was kind of, my issue there. The other issue, in the summertime, we have very little motorized vehicles because I have grass. So we don't have the hay. We don't need as much hay. In the winter, we need more hay, and it's really not used a lot in the wintertime with bicycles and more pedestrians. So in the winter, we tend to use it a little bit more. I think those were the only my aspects of, of dealing with coming in and out of the property. I need a farrier every 6 to 8 weeks in the summer. Wintertime, the shoes are off the 3 horses. They don't really need anything. And it's maybe we use it twice a month for hay. So, I mean, it's not used a lot. My biggest concern is veterinary services in an emergency situation. So, thank you.
Thank you very much. The next signed up is Katie Deline. Sure. State your name and address for the record, please.
Hi, my name is Beth Goldman. I'm 15 Huntwick Lane.
And I'm Glenn Goldman, also at 15 Huntwick Lane. We live right behind their property, and we initially started noticing some problems, I think around February, when it looked like the person that they were letting use their property started using the property to provide horseback riding lessons. And it was when those lessons were starting to be provided that a lot more access was on the trail. They were going down to the rink and providing lessons there, and it just seemed like there was a lot of traffic. And that's when we initially called and said, what's going on? There's a lot of, traffic on the trail.
So our issue isn't so much with them having access to bring hay once in a while and medical. And that wasn't, even though they were using it all the time, we never had an issue with that before the equestrian business began, because it wasn't a problem. But since the equestrian business began, First, they're using Cherry Moore South as their kind of like business access. So as a result, the cul-de-sac that is next to the entrance where they want to use to get in has been used as a parking lot, and we do have pictures that we can show you. So that's been used as a parking lot for all of the people taking lessons, for the man and woman that run the business, so their vans are there. Furthermore, apparently the people, the people running this business were also using One Huntwick, she'll get up and talk, as the kind of address for people to go to when they needed lessons. So people were literally, I guess, knocking on the door, but she'll explain. Furthermore, our property, because they don't have a gate on their property that's really big enough to kind of access properly from the actual path, they have to then back everything up onto our property, which I believe is ours. And, you know, we've asked that they don't do that because we have sprinklers and they're running over them. But one of the people running the property, I think at one time we said something about, you need a bigger gate, but they won't even do that. So for that reason, they've had, like, the farrier came recently, we have pictures of that. I guess they couldn't get in. The other problem is they have no shade on their property, so they're using our property as a place for all the families to hang out while they wait for their kids to take lessons. We have horses that come on the property and sit under the trees and feed. We believe they also have, when they're not feeding their animals certain times, they have kids in the neighborhood come do it. They're tying, you know, dogs to the trees. So what's happening is there's all kinds of garbage on our property because they're using it, and it also becomes a liability for us when we've got kids on horses hanging out.
Yeah, hanging out on our property. The concern of someone getting injured on our property is a concern. Also, I don't know what the city's thoughts are as far as the ring being used for a commercial business. I always thought the horse rink at Woody Hollow was for the community, not to run a business out of. So I don't know if that's something that's okay with the city or not, but it seems like that would be an additional problem, and that's led to, again, just additional traffic that's coming into our neighborhood that the Skolnicks don't see.
Yeah.
It's behind their property. They don't see how it impacts everyone in our community.
We have a lot of cars like speeding. A lot of people in our area have been complaining because there's a lot of kids in our neighborhood. So it's really impacted our neighborhood. I mean, I don't see why people taking lessons or people running that can't be parking over by their house and using their footbridge to cross. And their waiting area could be over by their stream, which I'm sure is gorgeous. So it just seems like, yes, they might need access for the medical and all of that, and we understand completely, but that's not what they're using it for. And they're only bringing this to light because of the complaints and because, I guess you could say, they were caught.
Right, and the other thing that, you know, is concerning as far as what they say they're doing versus what they're actually doing is that, you know, they were told they had a limited time to find an alternative problem or solution, and their solution was to cut the lock. And they repeatedly cut the chain and then rigged it so that they can get in whenever they want to get in. Even though the city said, we want to know when you're getting on the trail so we know what's going on, how much use it's getting. They didn't care what the city wanted. And that's concerning.
And then we also have some things that we'd like to kind of read from other neighbors that couldn't come. We only found out about this today because I think we should have maybe been warned, but we were not. So this is from Doug Robinson, who's at 11 Huntwick. It says, the access behind our house on the trail clearly has negative consequences to us and all of you. As a businessman, I would ask, at what price would we be in favor of granting access? My first thought is $400 a trip, divided half between the city and half to our HOA. I don't know why. The Skolnicks could then determine the economics of it, if it makes sense to do it this way or pay folks to use their bridge. I don't see why we should subsidize their money making efforts to run a commercial horse facility in our backyard. And then this is from, read this one first, from a mother, Paula Regan, and I forget what her address is.
I'm not sure.
Oh, none of them know, okay. says, over the past several months, there has been considerable traffic near my home to access the bridle path off the cul-de-sac at the end of Huntwick Lane. This traffic has included numerous vehicles, including cars needing access for riding lessons, being given at the pasture on the back of the property of 1635 East Layton Drive. I have a number of safety concerns regarding the magnitude of the traffic, including the safety of my family. These cars often use my driveway to turn around, which is a private property, and an area where my son with special needs is often playing basketball. The considerable amount of traffic in the neighborhood has led me to install security cameras on my property should an accident occur. I bought the property at 9 Huntwick Lane, basically at the top of the cul-de-sac in 2016, largely for the privacy and peace provided by the property. At the time, I was obviously not aware that the property at 1635 East Layton Drive was using access at the end of Huntwick Lane to conduct a business. Needless to say, I have grave concerns about the continued public access for the horse activity at 1635 East Layton Drive. In my opinion, the situation is unattainable given the safety and concern of the homeowners in Huntwick Lane, as well as the business nature of the use of the property that is not part of our neighborhood. So I'll read another. This one is from Darren and Anya Aldrich at 10 Huntwick. We're all kind of like right at the access. I want to voice our concern over the continued unauthorized access through Huntwick Court to the horse property at 1635 East Layton Drive. During the past several months, we have become aware of significant amounts of additional traffic through our neighborhood and numerous vehicles. 7 was the highest quantity we witnessed being parked on Huntwick Court, restricting access to the trail for bicycles and pedestrians. We have also witnessed trash being left on the cul-de-sac and the adjoining trail by the non-residents. It is our understanding and belief that the vehicles include people visiting the property at 1635 East Layton Drive for the purpose of equestrian lessons and a commercial enterprise. Access to CHV pathway is controlled through the use of a locked bollards to prevent unauthorized entry. The lock on the bollards on Huntwick Court has been cut, thus there is currently no control over the access. It is our understanding that access has been unlawful for the past 5 to 6 years, since the last recorded access request was in 2014. I'd like to request that the city deny the right to access the path since it has created an unreasonable burden and safety hazard to the citizens of our neighborhood. Then there's like a bunch of agreements. But also, can I just give this to you?
Yeah, well, if you'd like to leave a copy with
Yeah.
our clerk, that would be fine. We'll put it in the record.
Mayor, what is their address? I didn't catch that.
Of which?
Our address is 15 Huntwick Lane.
Thank you.
15 Huntwick.
Okay.
And where's that relative to?
Directly behind.
We're directly behind their property, the horse property.
So anyway, they'll pass the pictures around. So that's basically it. I mean, they're welcome to run a business. I know according to the city zoning.
It's,
But you're renting the business.
well, please, all comments that will be directed to me, and please, go ahead and proceed with your time. If you have anything more.
From what we understand is that they, what we think we understand is, when was it, about a year ago or so, they put up a sign, not them, the person that's supposedly just boarding, to get the neighborhood to pay for a cistern for water.
They put up a they had a GoFundMe account to put in a cistern so that people that had horses in another part of the neighborhood could move their horses there to the property behind us. And then once the cistern was installed, then that's when they started giving lessons back there. And it's our understanding that it's not the property owner that's giving lessons, but they're letting someone use the property and take care of their horses and board their horses there. And that's the person that's giving the lessons.
Right, so any of the information we've had is from those people.
Thank you, appreciate it. I think we understand.
Okay.
Thank you.
Now, Katie DeLine, Mr. Line.
Hello, I'm Katie DeLine. This is my husband, David DeLine, and we live at number 1 Huntwick Court, which is, if you're looking at this access we're talking
Number
about,
1.
Number 1. We're just the property to the right.
We're right at the end of the cul-de-sac.
Under the cul-de-sac. So we've been there since '97, been there 23 years roughly. This has just become an issue, like the Goldmans were saying, in about the last year or so. We're horse lovers. We love the idea of horses around here. So we fully support that. But there's just been a few too many issues with that access. We worry about, like everybody else, pedestrians, cyclists, anybody else going along there. When I see their boarder's van coming through to access the property, and I'm like, whoa, wait a minute, we're walking our dog right here. What's going on here? The code enforcer, I know, kind of ran her off for a bit, but that's obviously not okay. It's dangerous. We don't like, and along with many, many other of our neighbors, pretty much all of them have said something, chimed in. Like we said, we didn't have time to get, rally the troops. We just heard about this just at the last minute. But they all say, no, we don't want vehicles accessing back there unless it's for utilities and whatever's allowed. There's more traffic in our neighborhood. The Robinsons, who couldn't make it, but Doug made a statement. He didn't add that they've had 2 cars hit. They have a bunch of teenagers around, they're young adults now who have been around for COVID, and they've had to park a couple extra cars right by their driveway, but kind of in the cul-de-sac, which we do from time to time. And they've had 2 of their cars damaged, about thousands of dollars worth of damage. And they can't say it had to relate to the horse people, but it happened in the cul-de-sac. They do know that. The boarder, her cars are there, 1 or 2 cars are there twice a day, every day, to go feed the horses. And that's a little bit annoying for us to look at, but obviously, we can't, it's, I suppose a public cul-de-sac that we can't say too much about, but it's just a little bit of an annoyance. But just the danger of too many people on the trail with, you're going to grant, we're all for, a couple times a year of hay or a medical emergency or, some other occurrence that might come up. But this extra traffic, I was outside and this woman comes screaming down the street into the cul-de-sac in this big black Suburban, and she's like, "Are you number 1 Huntwick? Are you number 1 Huntwick?" I'm like, "Whoa, lady, what's going on?" And I knew, I'm like, "Oh yeah, you're with the horse lady over there. You've got kids going to a horse lesson, but you better slow down." So she had given out our address for the access for these lessons, and she had also put a garbage can and given the garbage company our address. And we said, no, we don't want any kind of liability related to your horse business. You take us off of any of that information. And so she, oh yeah, okay. So she kind of, I know the Skolnicks have this, they have the property, but it's this border that's really caused the problems lately. And that's why you're all having to address this 7 years later, or 6 years, whatever it's been, that they've been using the path without a whole lot of complaint, but it's just really come to light now with this business going on, which, as we agree with the other neighbors, we don't think that's right for her to be, she doesn't live here. She lives kind of across town, but she's running this business in our horse arena for the, that's there for the use of neighbors. I don't know what the public status is. She'll probably argue and say, oh, anybody can come from, North Denver to come run lessons out of there. I don't know, but that's caused a problem. And basically, I think that was the most of what I wanted to say. Just we have several other neighbors, Ryan's, Regan's, Houlihan's, Bears. Everybody agrees they don't want more vehicle access back there. They don't support it. They think it's dangerous. They don't like the extra traffic coming through Huntwick. It's not our problem. We're just the adjacent neighborhood. It's their property. They need to access through their property. That's all I have to say. Thank you.
Thank you very much.
Yeah, I just add that the traffic has greatly increased through our neighborhood. And let's face it, traffic around this town is already bad enough, and nobody wants it coming through their neighborhood. And all these people are coming in here, and they're accessing through their supposed hay access or veterinarian access, but they're accessing it for this business that's being run there. And I guess I don't really have a problem with that, but let them ask access to their home then, their main access, not our access. That's taking advantage, and it's going to end up, hopefully not in some kind of tragedy, because someone is screaming through the neighborhood, and a kid is out in the street, and they get hit by a car who shouldn't be there. So that's kind of where we are. Let them access through their main access and see how their neighbors feel about people coming over for horse lessons. Not our neighborhood. They're not part of our neighborhood.
I guess the one thing I'd like to add too is we just don't want to see a precedent, you know, for our hay and medical and whatever we need. So no problem. We've got a key. I think that's very dangerous and adding way too much traffic, foot traffic.
The last thing I'll add is that the end of our cul-de-sac, and we didn't buy a house on the end of the cul-de-sac to see a parking lot at the end of the cul-de-sac. Every day there is a car parked at the cul-de-sac. It's either parked there or at the end of Vineway. And they play a little game of trying to park one day here, one day there, one day there. But they're the same cars and it's the same people running the business. So let them access to their property, not our neighborhood or Cherrymore neighborhood. And this was never a problem until this business started probably 9-12 months ago.
Okay, thank you. Appreciate it.
For council's reference, since I know you probably don't have the code in front of you, the section of the code 16.2.730 about horse boarding on properties does specify that all the parking, including for horse trailers, has to be provided on site.
Anybody else wish to speak to this issue? Oh, Rob?
Hello, everybody. One moment, let me get back to my right materials here. I appreciate an opportunity. Good evening, Mayor. Good evening, members of the City Council. I apologize that I was unable to attend the PTRC meeting when this matter was addressed before the commission. I understand this owner seeks to use a public trail for private purposes of getting feed and supplies to a barn. It appears also from some of the prior public comments that it is to facilitate a private business operation within the village. PTRC reviewed and voted to recommend a temporary revocable license with conditions that were attached. And my understanding is that city staff has asked you to deny the requested relief from the property owner. The facts of this are that the owner bought the property in approximately 2011. It was subject to the laws and easements and the dedicated public trails that were in place at the time, and therefore it is bound. The representation by the property owner earlier tonight saying that the prior easement does not seem to make any sense to me legally, and I urge you to work with city staff and legal counsel for the city to better understand, because it doesn't make sense to me. It seems to me that the property owner bought the property subject to the easements that were in place of the public right of way, and the laws apply to public rights of way, that there is no vehicular access or motorized vehicle use on those. The fact that they pay property taxes is not at all unique and a basis upon which to grant the requested relief, because once they become a public trail to the city, they are subject to all the trail requirements, including the lack of ability to have to have motorized vehicles on them. This property, the home is at the top of a hill of a long, thin property that crosses Little Dry Creek as it slopes to the east down to a flat area at the east where the village open space trail exists. This owner bought with knowledge of the law and the conditions. It later sought a building permit for a barn. It never mentioned access in the application to the building properties, but now it argues that it would be untenable for the city to have granted a building permit without considering the fact that they would need to have access. In reality, they did have access. There already is a trail there. So to speak, they have put the cart before the horse. They have built a barn, and now they are asking you to provide them easy access to facilitate large deliveries of hay and supplies over a public right of access. My understanding is that they had a temporary license that lapsed years ago. It was negotiated solely by the former city manager with no public involvement and no city staff review or input. The agreement was temporary, and the license is clear in its terms that it was only in place while the owner sought other means to obtain access. The record is void of any evidence as to any efforts that the owner took to seek other means of delivering the supplies and to provide access either from its other neighbors or to improve a bridge over Little Dry Creek, or to even have some other engineered solution to be able to deliver supplies to the barn. Simply put, this has been nothing more than a continued trespass and illegal use of the city's public right-of-way. In the record, the owner blames his boarder for failure to follow the requirements of the temporary license, as well as its now failure to follow and continue to have trespassing going on the property. This owner unfortunately takes no responsibility for his failure to follow the terms of the license and to heed its termination, nor to make sure that its own tenant takes adequate efforts to comply with the law. In short, he's failed to read the license or follow the temporary license terms. My understanding is that this issue has come to a head recently because, frankly, the owner got caught, or the activity has caused such a stir that it is now no longer tenable to have, and has come before PTRC and now before you. It is my understanding that the current owner has threatened litigation if the city doesn't grant what the owner wants in terms of that are fully acceptable to the owner. The owner asserts a failure to grant the license to cross the public right-of-way and public open space trail effects to a taking of its property. The owner now states that he needs the access, and thus the city should yield some of its property rights and grant a license. Earlier, when the applicant made his speech and presentation before you tonight, he said that he just wants to be able to use his private property rights. And when he purchased the property, as I mentioned earlier, he bought subject to those property rights that allowed this to be a public trail and all the requirements and limitations of that, despite the fact that they do pay taxes. They have a reason to be bound by the fact that there is a public trail there. The license, in my understanding, is that they're not just seeking any license. They want it to be unrestricted in terms of notice, no coordination with the city, no indemnification for the city for potential injury for those using the public trail. And by the way, our trails are a cherished part of our village open space program and should not and are not easily relinquished of any of the property rights that go with that. In short, had I been able to participate in the PTRC review of this matter, I would have voted to deny their request in full. Open space, as you know, is a village treasure and is highly valued. The city should not subvert its open space property rights to private use. Property rights are sanctimonious and cannot be given away and should not be given away. The city has a duty, in fact, a requirement to act on behalf of all the city residents and people who make use of public trails and paths to make sure that they are open and safe for usage. That would not be the case for what this owner wants and has asked for. While he has asked to seemingly something that may be reasonable tonight, in fact, his behavior and written statements imply something very differently, and an unwillingness to work with the city to try and reach a potential solution. Secondly, the horrible precedent that this matter sets is clear. There are many places in the village where it is easier to access rear sides of property, side sides of property from public spaces. Here it may be a steep slope. Elsewhere it may be because of prized landscaping or a tennis court or a swimming pool makes access difficult compared to using open spaces and paths. In fact, the record is clear that apparently the owner made a representation that to be able to put something in that would access the backside would require the steep slope to be having, in essence, a bridge or something like that go over their swimming pool. I think the precedent is clear and is not something that you all and the city wants to have. Thirdly, the owner demonstrates no need. Want, yes. Need, no. This problem is self-made. No efforts to work with the existing bridge or to modify the needs were made. No showing of engineering solution was made by the owners of the property. No record of any efforts were made
to work with the adjacent owners to obtain an easement or an agreement that comes in off of another section. My understanding is that this is a periodic need and could easily be handled by a series of temporary licenses, no different than when a utility company needs access onto a public right of way. But my understanding is that this property owner has said that that is not acceptable to have any kind of restrictions placed upon any kind of an agreement, and that this owner would litigate if he was subject to any kind of restrictions. This owner, in short, has looked to government to solve his lack of foresight and planning. It should decline to grant this owner the relief that he now seeks. Some of my colleagues expressed sympathy, some of my colleagues on PTRC expressed sympathy for the owner's plight, but he alone has now created it. He bought property without considering how to legally accomplish his goals, and the record indicates he has been less than forthcoming about the temporary license terms and then resorted to litigation threats that would argue the city committed the takings. The council should not reward such behavior and tactics, and based on the evidence that I've heard from other public commenters tonight, it appears that it has not been a cooperative working with relationship with the rest of the neighborhood as well. No takings would have occurred if the request is denied. The owner has the entire bundle of sticks he had when he purchased the property, and he has not suffered a loss of any of those rights. He now argues that it would be wrong to have given a building permit without allowing access, but he is wrong. He still has access and can get all the supplies to his animals. It would be more difficult and more expensive, but he can still do it. The city would not commit any kind of a takings if it declines this. The government is not in the role and should not step in here to have guessed that he would need easier access than he already had. The city, in short, should not save him from his lack of planning or paying what it takes to get food and to his choice of having animals on the eastern portion of the property at the expense of the sanctity and the wonderful importance that we place on our public trails and their use. Thank you very much for your time.
Okay. If there's no other comments, I'll ask council members to speak if they wish to speak to this before we entertain a motion. Councilor Blum?
I notice, I appreciate everybody coming in and expressing their opinions on this. I think there are a number of issues, two major issues, really. One is our code is very specific, and they bought the property subject to the code, the Skolniks did, and knowing that no motorized vehicle, and I think our section 11.380 is very specific as to what type of motorized vehicles are allowed there. I do appreciate their plight. Understand they have, seems to me, more economic concerns about delivering hay and services to the barn. But the other evidence I think that we heard tonight, and we heard a lot of it, and we received a number of it in writing, is that there is somewhat of a nuisance there that has happened and occurred, and it's probably, seems to me, is being promulgated by the activity that's going on down at the end of Huntwick Lane, which creates some concerns for the people living at 1 Huntwick and also the people I think this spoke about on 15 Huntwick Lane. And I think that's a major issue that is beyond the scope of what the request is here tonight. So based upon that, those would be my comments before we go to any further discussion.
Councilor Sheldon, would you like to chime in?
Thank you, Mayor. I've got four comments. Number one, I have some concern about the overall safety of our residents and outside residents who might use Trail 2047 without any kind of traffic control occurring on that trail. Number two, I have a concern about running any kind of commercial operation in there, whether it is the applicant or the applicant's tenant running a commercial operation. Number three, I assume that the plat was recorded with this easement either in place as part of that plat or it was recorded as a separate instrument after that plat. But prior to 2011, which leads me to number 4. And I think Chair Eber from PTRC summed this up very clearly. In 2011, the Dry Creek alignment is exactly where it was in 2011 is where it is today. And my guess is that the applicant bought this property subject to the easement in place and has created his own problem as well. And to that end, unless other testimony is provided, I don't think I can support a request for further licensing agreements. Thank you.
Councilor Gallagher.
Yes, you know, what's interesting, there's consensus that to take care of horses and allow them to get hay and to get veterinary services and farrier services, what I heard from neighbors is that is not that big of an issue. That what the issue is this business that's taking place and everything that goes around that business. And I have genuine concerns about that as well, because you, those neighbors where you bought a home at the end of a cul-de-sac for a reason, and now that becomes the staging for a business, and it's a very legitimate remark from the person making the comment. I think there's a bigger issue here, though, in that we as a community, we don't have a policy for, our policy now states that if you drive a motor vehicle on the trail, that is our policy. You can't do that. And there probably are, obviously with a few exceptions that are built into the code, you can put motor vehicles on trails. But I look at you're directly to the south, your property, ma'am? Yes. You have the landscape? Right. I look at that and I could see it that whatever we decided tonight, that you could be coming forward, 2 months from now, saying, I need access to this property. And my point is, we probably need to direct staff to come up with a policy that makes sense when it is appropriate to, where you have this unique properties like this, and listen to staff. And so I'm not really ready to vote on it, but I think we don't have a policy as a city for those exceptions.
Councilor Brown.
Thank you to everyone who came. I do appreciate the challenge of the situation. But I am inclined to agree that, first of all, the nature of the original agreement is quite clearly temporary. That is repeated in a lot of different places. And, the fact that it's even continued this long, whether lawfully or not, is a concern. And I agree that it seems that the larger concern is the commercial use of the property. And I don't know, I guess I would look to city attorney for, if you have any guidance. I don't feel like that part of this issue was addressed in any of the materials, and I don't know that I have the information I would need. Obviously, it allows, boarding is allowed, but we had a similar concern on a different property about some types of lessons being provided, and that was most clearly not allowed. So I'm not sure if horses are different from dogs.
I just learned about these commercial operations this evening.
Right.
But there are home occupation regulations in place that definitely are confined, and we can.
Right. So I think that in itself is a whole separate issue, and And to be frank, the fact that it's not the homeowner makes it an even larger issue, because home occupation is allowed, but commercial businesses are clearly not. So that has a whole set of tentacles that need to be potentially addressed. But the other question is, I guess also for city attorney, is a medical, we do allow vehicles on the trails for emergencies, including medical emergencies. I can imagine that getting a horse to the front of the property in a medical emergency might be exceedingly difficult. So I'm assuming that a medical emergency related to an animal like a horse, would that be allowed? Is that considered an emergency use?
Well, the word actually doesn't say emergency. There's an exception for police, fire, ambulance, and other park fire protection, other public vehicle. It doesn't actually say the word emergency, but I think it's reasonable to interpret this provision. I don't personally know if there's horse ambulances.
I don't know either.
But there's some sort of veterinary vehicle somehow to get a colicky horse somewhere, I would imagine. And I would interpret this to allow emergency access to save whatever lives are on the property.
Okay. Because that concern I do completely agree with. I think that people should have that we shouldn't let these kinds of regulations interfere with real safety issues, whether it's humans or animals. But I think that what has occurred, and I appreciate the acknowledgement of the neighbors that these are public roads and people can park on them. And it is a nuisance when, people are parked there constantly, but it's the commercial aspect that complicates that. That is clearly not allowed, if I remember correctly, that all of the parking has to be provided for on your own property. So if people are parking at that cul-de-sac to access the trail for walking or for whatever purpose, as annoying as it might be to have a lot of cars out there, it is a public road and a public cul-de-sac. But if they're parking there to access a commercial enterprise, and particularly one that's benefiting somebody who doesn't even live there, I think that creates a huge challenge in this particular situation, whether we were to grant this easement or not. So, I also agree that it was a temporary issue or a temporary agreement, which should have allowed appropriate, adequate time. An extension was even given, which should have allowed adequate time to develop another solution. I understand there's not an easy one, but that's the double-edged sword of having a beautiful stream through your property. And so I'm not inclined. We have a lot of other people who would like to access trails with their golf carts, and they can't take them on roads because they're not street legal. We have a lot of other people who, was pointed out, would be much easier to access other parts of their property from public property. And I think that it's not an area that I think our code represents the desire of the city in that sense, that's not allowed. So.
Councilor Wheel.
Thank you, Mayor. Seems to me there's two issues. One is the excess, and the other is this question of commercial business. And I don't want to be repetitive, but I believe that in our code it requires licenses and permits and other things if there's a commercial business. And I realize that is not the main topic tonight, but it seems to me that needs to get cleaned up and made conforming to our code in the event that it does exist. Beyond that, the access really wasn't a problem until this extra traffic, parking, all of that exercised the neighbors. But I do agree that the original license was temporary, and there was expectation of remedy for the access. I don't think it's the city's responsibility to make assumptions or provide, deny building permits because the access isn't worked out at the time the building request is there. So I'm not very supportive of what's going on, or the request at the moment, I guess I should say. But I want to thank everybody for the time and the effort that went into, and the thoughtfulness that went into both sides of preparing for both sides of it.
Councilor Safavi.
Yeah, again, thank you for everybody for speaking up and presenting your view, your case. To just save some time, I guess I summarized that I agree with everything that the other councilors mentioned. Just want to add one point. I believe, you know, as I'm listening to this, the neighbors are actually being pretty reasonable in a sense that they're saying, you want to go ahead and use this access for feeding your horses as it was agreed on, you know, a couple times a year, whatever the agreement was. You know, if there is an animal that is sick, you need to go ahead and have access to care for this animal. You can have that. I think if the request was coming in to say, look, we're not using it for the summertime as much, grant us, you know, a little bit more access, maybe a couple more times during that 5-6 months or a couple months, you know, during winter time, I can understand that. I can be supportive of it. But in this case, it is really the commercial use of the property that sort of tilts my vote or my decision to not grant the, you know, again, what is being asked. So that's all, Mayor. Thank you.
Thank you, Councilor Safavi. If I could just add a couple things to follow up on some of the comments. There are, our charter has a section 12.4, which allows the council to grant permits for temporary use or occupation of any street, alley, or public place. So it's really a permit issue, I think, as I see it, in my view, this is a permit issue about whether the council has to do it. It can't be the city manager. This is something that's delegated to the council, unless council delegates it to someone else. But that doesn't really get at the issue. The real issue is the motor vehicles, because that's, you know, they're under our current 11.380, they're not allowed of any kind. And so it's what essentially was done before was a revocable license was granted that conflicts with the provisions in our code that don't allow motor vehicles. But what I'm suggesting, and follow up on Councilor Gallagher, is I think we need to take a look at this. I would be in favor of taking a look at this whole thing. We have other issues with electrical vehicles on the Highline Canal. I think that falls into here too, because those are also prohibited by this exact language. And we need to address that. We either have to decide whether they're really prohibited or whether we should change this language. We may want at the same time change this language to allow what I think is a reasonable use of access to that the neighbors have indicated to get hay onto the property a couple times a month or do that, which nobody seems to have a problem with. So, and I also note that our code on section 11.350 allows the city manager to promulgate rules for permits. So, you know, we could, staff could take this up. I would be in favor of having staff take a look at this. I think there are broader issues than simply this license agreement, which I think, you know, ought to be a permit and ought to be, if we're going to do it, we ought to have a policy for others. And I particularly take Councilor Gallagher's point. There are other trails in our community that have gates that open onto them, and I'm pretty sure that they're being used by individuals with motorized vehicles, maybe entirely appropriately, maybe once or twice a year, but it just is, and there are reasonable reasons to do that. But some type of a policy that applies to everyone equally, that allows the city manager to make a decision on this that we adopt, I think would be really useful going forward. So those are my thoughts, and I do agree that there's a separate whole issue with the new issue about commercial use and that, and I just can't speak to that because I haven't even thought about it in detail, and I don't think the council can think about that in detail now. But and that's what I think I'm hearing. So I think that sums it up. I think everybody, unless anybody has any other comments, I can entertain a motion. Nick, just council. Sorry. Any other councils or a motion?
I move to deny the request for a revocable license for vehicular use of Trail 2047.
Second. I have a motion, a second. Is there any further discussion?
Mayor, I think your suggestion was a very good suggestion that staff look at this. I think it's appropriate now to pass this motion denying this, but I think it's something we do need to look forward to, especially as we discussed earlier, the fact that there are electrical bicycles going up and down our trails too. So that's something that we really consider in the future, whether it's study session or something staff needs to look at right now.
We can make that part of the motion if you like, amendment to the motion to add that. Is there any objection to that being added?
Or I'm happy to make a second motion to that effect too, actually, if you want to.
We have a motion?
Go ahead, Katie, make a
Well,
second.
Actually-
let's vote on, do you want it as part of it, or?
Oh, no, no.
Okay,
You
look-
want to do a
look-
separate motion? That's fine. Let's
Yeah.
go ahead and vote on this motion. The main motion then, we'll go ahead and vote. We don't need a roll call. This is just a voice vote, right? All in favor?
Aye.
Any opposed? Counselor Brown?
I move to direct staff to research section 11-3-80, operation of motor vehicles, and to develop a policy, to consider developing a policy around appropriate use of motor vehicles on city trails and public spaces.
Second.
I have a motion and a second. Any further discussion on that motion?
One comment, and I think Katie raised an important point, that as far as, and I think council reflected that, the fact that there may be a medical emergency, they would be able to access this, and I think that's important that the Skolniks know that if there was a medical emergency, that could be done.
Mr. Mayor, in regards to the motion, I might just offer that we incorporate PTRC in that process. Because
Absolutely.
I know they've actually already started, and Emily can talk about this more, they are actually discussing this exact topic.
So I guess we'd
already.
be asking PTRC
You know,
to
I-
research and consider that.
I think that's a really good idea because as I looked at the PTRC enabling statute today, they would benefit from us giving a motion to them to do this. Otherwise, I'm not sure it's within their authority to do it.
Yeah.
But
So
I would like to have.
So I
that
changed that, I moved that it's PTRC that researches that and provides suggestions and proposal to
with the
council.
staff.
With, yes, in conjunction with staff.
Do we have that
Second?
written down now? I think we already have it.
Laura's a very good interpreter.
I think we already have a motion and second for that
Yeah.
motion. Okay, we got it. All right, all in favor, voice vote?
Aye.
Aye. Any opposed? Thank you, everybody. Thank you all for coming, and thank you for your comments. They were very, very helpful to our deliberation. All right, next up is agenda item 10B, Council Bill 7, Series 2020. Amending Section 7130 and 7140, Section 181160 of the Municipal Code related to noise, nuisance, and construction times, amending Section 7310 to correct a clerical error. Chris?
Good evening, Mr. Mayor, members of council. To be consistent with the process throughout, actually, City Attorney Guckenberger is going to bring us home on this presentation, consistent with the previous presentations.
We are on third base and close to home here. This is first reading of this ordinance. You guys all saw this in study session. This version of the ordinance incorporates some of the grammatical changes suggested by Councilmember Wheel. But other than that, there are no changes to this ordinance as you have seen it before. It specifically allows for an exception, or permits an exception for lawn mowing activity, which is louder than the typical specified decibel level, except for it subjects commercial operators of that activity to construction times as set forth in Chapter 18 of your municipal code, which is your building regulations. And similarly, in that same section, the construction activity is now revised to permit inside construction activity. It used to prohibit that on federal holidays, permitted it on Sundays, and now it's permitted just as if it were on Sundays. So that's all there is, and if council is in favor of approving this ordinance, you could propose a motion to pass this ordinance on first reading.
Is there a motion attached? Let's see. Actually, there's not a proposed motion.
I didn't see that in the staff report. But
We can do that.
simply read.
We can do that.
Move to accept, move to
Yeah,
approve.
we can do that.
Yeah.
Yeah.
Any
You can
comments
do that,
first
yeah.
before we, Councilor Blunt?
My only comment is that I really don't want to be the undesirable plant management advisory commission.
I'm sorry.
I appoint Lucinda Green To be the undesirable plant management advisory commissioner.
Yeah, it is by state law required to
know.
be the governing body, and as I said, this is a scrivener's error, and you actually have a weed management policy in place that's administrative, so you don't have to do anything.
You learn something new every day. I didn't know that I'm going to start putting that on my resume.
Yeah, there you go, if you want that, yeah, so move to approve the Council Bill 7 on first reading.
Is there any other comments before we make a motion? Councilor Brown, do you want to make the motion?
Sure. I move to approve Council Bill 7, Series 2020, an ordinance amending Section 7-130, Section 7-140, and Section 18-11-6C of the Cherry Hills Village Municipal Code relating to noise, nuisance, and construction times, and amending Section 7-3-10 to correct a clerical error.
We have a motion and a second. Any further discussion? Hearing none, we'll need a roll call for this.
Counselor Safavi?
Yes.
Counselor Wheel?
Yes.
Counselor Brown?
Yes?
Counselor Gallagher?
Yes.
Counselor Sheldon?
Yes.
Counselor Blum?
Yes.
That passes unanimously. Next, we'll take up agenda item 10C, Resolution 27, Series 2020, canceling the November 3rd, 2020 regular municipal election of our village in accordance with Section 2-1-30 of the Cherry Hills Village Municipal Code. Laura.
Good evening, Mayor Stewart, members of City Council. Staff is presenting for Council's consideration tonight a resolution canceling our regular municipal election. We have met the two requirements, which is that we don't have any ballot issues or ballot measures at the city level, and we only have one candidate per position, including write-in candidate affidavits, of which we got none. And so we are presenting this resolution to cancel the election and direct myself as city clerk to deem the four candidates to be elected. And if council approves this, then we'll publish a notice in the Villager and let all the necessary organizations know, and the new members will be, or the incumbent members, will be sworn in at the first organizational meeting in January. And I'd be happy to answer any questions.
What's the financial impact of this? How much does it cost us?
We will kind of cancel our IGA with Arapahoe County. Any expenditures thus far, they are able to charge us for, but the vast majority of that $7,000 we won't have spent it.
Any other comments? Any motion?
I'll defer to you guys.
All right.
Mayor, oh, sorry.
Yes.
Somebody speaking?
Councilor Sheldon?
Yeah, just a quick question for Laura. Does this mean that there will literally not be names then on that November ballot, even though I think last time when there was only one person running, it was one name. Will that be the same as it was last time?
Right, so this time the city, and there won't be any names, and the city won't show up on the ballot. Last time, because we did have more than one candidate for a position, that meant we had to publish all the candidates for all the positions, whether or not there was more than one candidate for all the positions. So in this case, the city of Cherry Hills Village just won't show up on the ballot at all.
Got it. Thank you.
There is a recommended motion.
All right. I move to approve Resolution 27, Series 2020, canceling the November 3rd, 2020 regular municipal election in accordance with Section 2-150 of the Cherry Hills Village Municipal Code.
Second.
Motion and second. All in favor?
Aye.
And congratulations to the winners. Next, agenda item 10D, Quincy Farm Committee recommendations. That'll be City Manager.
Good evening, Mr. Mayor, members of council. This item is in regards to two recommendations made by the Quincy Farm Committee regarding the receiving of a letter of interest for the farm itself. Natalie Anderson, the granddaughter of Kat Anderson, has submitted this letter of interest to the city about expressing an interest in potential transfer of the Quincy Farm back to the Anderson family. The transfer to the Anderson family is allowed through the conservation easement, and the conservation easement would stay with the property in the event of this proposed transfer. On August 18th, the Quincy Farm Committee met and made two recommendations to City Council. The first is to suspend the master plan process. And the second is the committee recommends to City Council that the city fully explore the opportunity and potential transfer of the farm outlined in the letter. Staff would add that we are also seeking input regarding the meeting schedule of the Quincy Farm Committee as it relates to the continued work with the master plan process. So with that, there is the recommended motion pending upon council's discussion of the two items before you tonight.
Okay, I'll take comments and questions from council. Councilor Blum? Councilor Sheldon, sorry, didn't want to miss you.
Mayor, are you asking me if I have any comments?
Any comments? Yes.
Not at this time, thank you.
Councilor Gallagher?
I am in favor of making these changes, and I welcome Natalie and your team, and I think it will be very helpful as staff and your team works together. I think it makes sense to suspend meetings at this time, but it's very important to be working elbow to elbow, or at least keeping the Quincy Farm Committee very well informed through this process. And I think you all know each other well, and I think you'll work together well, but I think it needs to be said publicly how important that is, because you committee members have invested an incredible amount of time and effort to get to this point, and so it's valued, I guess is my point to you, to the Quincy Farm members. And the last thing we want to do is drop you, at this point in the process. So that would be my comment, is that you continue to work closely.
Councilor Brown?
I had a question about, the contract for the master plan was for about $30,000, a little over that. Have all of those funds been spent?
So the contract for the master plan itself was $59,000, and then there was a $30,000 add-on that was the historic structure assessment piece. So the master plan itself was very close to finished. We have had draft site plans, a final site plan, and then a draft written document. But the committee got a lot of feedback really late in the process. So the committee was about to come back to council and ask for additional funds to sort of back up in that process and start with a new site plan. But the services that we are contracted for the master plan are nearly complete, but the plan itself was not, there was not complete agreement on the form of the plan as it is right now.
So then we've actually spent more like $100,000, if you include the
With two,
historical
yes,
assessment.
with the two together. So right now we have spent $82,000
Okay.
of the original $90,000 that was contracted.
And are we, as part of the contract, are we committed to paying the rest of that?
We are not. If we've basically hit pause with the contractor at this point, so under the terms of the contract, we could stop the agreement now and not pay anymore.
Okay. So I do, and I understand, and in theory, I support the idea that we're working under. $82,000 of taxpayer money for a document that's 98% done. I have a problem with that personally, both as a council member and my own, what I see as my responsibility to the citizens, and also as a taxpayer. I understand that there was not agreement on the document, and of course that would have come, the document was never actually formally even presented to council, and those were multiple steps in the process. But I would like to see, I want to make sure that we have at least received the work product for everything that we've paid for. And, I guess I would like to see that we don't have to adopt that master plan. We don't even have to take it up for discussion. But I have a real problem with just tossing it out the window after all of the volunteer work that has gone into it, all of the money that has gone into it, all of the discussions that have gone into it. That I can't really I can't support completely tossing it out the window. So I would like to see that finalized. I don't want to spend more money on it, so I'm certainly not in favor of backing the process up and opening it all up back again. But I would like to see at least the work that's been done to date, if there's a little bit more work to finalize that as the master plan that was, so that we have that. I also think that it does reflect, it reflects a lot of ideas. Obviously, there were some ideas that were pretty controversial, but it reflects a lot of thinking about what the vision of the citizens of Cherry Hills Village was, and those are valid opinions as well, just as valid as anyone who disagreed with those ideas. And so I would like to keep them for reference. I think as we move forward in looking at any potential partner for the farm, it would be nice to have something that documents what a potential vision was, so that we can talk to those partners about, what, if any of this, do you agree with? What, if any of this, would you have done differently? Where is there alignment in what this vision was and what that vision was? There were a lot of very, very dedicated, very knowledgeable volunteers, some of whom are in the room, whose opinions I highly respect. And I would like to at least have that, for our reference. So that's kind of the suspend the, to suspend the master plan. I'm actually more in favor of finishing out the master plan in the form that it's in now. I also, however, am in favor of looking at a potential partner. I think that Ms. Anderson raises some very valid points about the fact that, and this has come to fruition as well. This is a lot of money, and as I am always saying, it's taxpayer money. And that puts a very different standard on everything when it's taxpayer money. So I am in favor of looking to see if transfer of the property might not be in everyone's best interest and to be a win-win for the entire community. I think it's very important. I'm glad to see that the Land Preserve has been involved. I think, I remember discussions from back in the day that the Land Preserve might even be an option for taking ownership of the property. And, I guess I'd love to see that as an option to be considered as well. So I look forward to whatever. I know everyone's working together. I think that's wonderful. That's the most productive way to do it. And I look forward to seeing what options are brought to the table.
Thank you, Councilor Brown. Councilor Wheel.
Thank you, Mayor. A couple of thoughts crossed my mind. Certainly, I agree with, I think Katie raises great points about it would be worthwhile considering the inputs as a part of this. I think that Natalie's offer, or at least expression of interest, I should say, is just marvelous, because I can see how that can work very, very well for so many constituencies beyond herself, neighbors, tenants, and all of that. So I'm all in favor of pursuing that. I think that it's logical. Did we put the brakes on the expenditures because we're kind of in a limbo state? However, I think what's missing is some kind of a fuse or a deadline. And in that sense, I think we should, say it's complicated, it's not simple. And I don't think it's something either party wants to rush, but at the same time, this is pretty much open-ended. So I would like to see something more like, well, okay, let's suspend activities for 60 days, and come October, we have September and October. Come the beginning of November, we revisit this whole question again and see where we are, if things haven't already transpired by then. That's all I have.
Councillor Safavi.
So I'm going to keep it short. I'm in favor of the transfer. I think it's a great move for the city, for the property. I echo what Councilor Gallagher said as well, that a lot of work has gone into this master plan, and so let's now take advantage of it as much as you can. Of course, I don't need to go lecture. You guys are all, ladies are all team players. Just work together, bring it home, come up with the set date when you want to make the transfer happen, and let's just bring this home. I love the idea, and I'd love to see where this will go in the next year or two. So that's my position.
I'm going to just add one comment too, that maybe what you were raising your hand for, which is there's a piece of this called the historical structure assessment, which I think we need to speak to, because it is on a different path, and I understand it may have some independent value to complete for if this transfer does go through and the possibility and this comes to fruition, that may be very valuable to Ms. Anderson. And could you bring us, Emily, up to speed on how much we spent and how much more to go on that piece of it?
Sure. So what I was starting to say, sorry, before I get to that point, was that we do, just to assure council, we have all of the research that the consultant did, all of their notes from their meetings. All three site plans, or all three versions of the site plan, are up on our website right now, as is the draft written master plan, all 130 pages of it. So we do, just to assure you, we do have all of the work that the consultant has done to date. So that's not something to worry about. The historic structure assessments, that's the $30,000 of this contract that was an added service. They are really to look at each of the historic buildings and determine the deficiencies of each building, and really the steps that need to be taken to make those buildings safe for whatever future use you're planning for them. So the original amount for that was $30,750. We've spent $23,062. So we have about $7,687 left of that service. They're about 75% done. So, and they'll have value whether the property stays in the city's hands or whether it transfers to the Anderson family. So that might be something that council wants to discuss.
And we can take care of that within the existing budget, that we have the monies we have to finish out that piece of it?
Yes, that was budgeted, yes.
May I ask a question to clarify? I think that if I understood it correctly, we've spent sort of 3/4 of the amount, and we've got about 1/4 left to spend, and for that 1/4, we end up with a completed work product?
That's correct, for the historic structure assessments. So they were to be inserted into the master plan, but they are a standalone assessment of those buildings.
Okay, yeah. Should we deal with it as two topics? Or?
We could deal with it together and just amend the motion kind of to, if that's the sense of council, to proceed with that, because there is money in the budget to do that. And I agree, and I certainly agree on the comment. I agree with Councilor Brown too. We should get whatever we paid for from the consultant. But if we, whatever they've done, because I don't think all the sections are completed right in the draft that I've seen. So
most of the sections that are remaining are actually for city staff to complete, which we had negotiated with the consultant when we were putting the contract together, because some of them, like maintenance, a maintenance plan, made more sense for staff to write. And so most of the amount that's left for the consultant is taking information from us and inserting it into the plan, and also making some tweaks that they expected the committee to have.
But I do think the point is well taken too, that the HSA, to the extent, is really valuable for whoever does it. So I think it would be wise to go ahead with that if we want to make that part of the motion.
So related to the HSAs, if that extremely reasonable thought was given to allow that process to continue on, since it has no policy that needs to be voted on by the committee. It's a technical exercise. There will need to be some additional, you might consider in your motion on that, so it may make sense to be a separate motion, but it may make sense because the term of the contract is expiring September 3rd, that you authorize staff to negotiate an extension of that term that allows the mayor to then sign when that extension is complete. And Kathy, I'm gonna enlist Kathy's help here, but
I just say, for that limited scope of
just for
completing
the HSAs.
To the HSA. So you're saying actually a separate motion for the HSA following
Yes.
the motion? Okay. So I think that's, so if I'll agree that consensus of council is that what I'm hearing is to go ahead with the motion that's been presented, and then following that, we'll take up another motion just with the HSA piece. Councilor Gallagher or Councilor Blum? I see you both reaching. Who's first?
I move that the city suspend all activities related to the Quincy Farm Master Plan and fully explore the opportunity of a potential transfer of Quincy Farm outlined in the letter of interest from the Anderson family.
Second.
Motion and second. That's a voice vote. All in favor?
Well, I actually, sorry, I have one comment.
Sure.
I want to be very clear that the motion says to fully explore the opportunity of a potential transfer. I know Counselor Safavi is ready to make the transfer tomorrow. I want to be very clear that I am not. And I don't want there to be any misgivings or hard feelings with anyone in the room. I think it is worth considering, but I do not have nearly enough information about what that would look like and how that would work to commit to that at this point. So I just want to be very clear that all I'm personally agreeing to is to explore the opportunity.
And I think that's a good point, because I'm sure that's from the Anderson perspective too. They're not ready to make that decision of transferring tomorrow. So this is an exploration issue. Is that good? I think Councilor Gallagher, the read it verbatim.
Yeah.
Well, it's your emphasis, and I appreciate that.
Yeah, and I just want to then state, I am ready to transfer right now. So I'm just going with this because they want to explore. So let's go ahead.
Any other comments? Let's see, we have a motion and a second. All in favor?
Aye.
Aye, so that passes.
Aye.
Aye, thank you, Councilor Sheldon. Next, Councilor Gallagher, would you like to, did you have it written down? Not ready?
Authorize staff to extend the agreement for the term of the consultant. Authorize staff to extend the contract with the consultant specifically for the historical, give me the next word,
Structural?
structural assessment.
That then requires mayor's signature.
That requires a mayor's signature following the extension of the agreement.
Yes, correct.
We have a motion. Do you have a second? Councilor Blum seconded. Any other discussion? Hearing none, all in favor?
Aye.
Aye. Passes unanimously. Thank you, everyone, for the work you're doing. And thank you for coming. And Ms. Anderson, good to see you. Thank you for coming tonight. And Ms. Green, the chair of our committee, thank you for coming. And, oh, the head of the land preserve, too. Everybody is here in force tonight. Thank you. Okay, reports. I'll be brief. I was out for a while. Actually, last week we were at the CML virtual conference, the CML annual meeting by Zoom. I thought the most interesting thing I saw, and maybe Councilor Gallagher, he had a news clipping from it, but the interesting presentation I heard was on the ransomware from that is going on. And wow, it was a great presentation, and really, I hope we've all addressed that and we're backing up every night. It makes you really be nervous about what happened. And then, as if on cue, I think the city of Lafayette, like 2 days later, they get a ransomware and had to pay thousands of dollars to get their computers unlocked. So anyway, I thought it was interesting CML annual conference and lots of good stuff, but very different on Zoom. That's my report. Any others? Councilor Blum?
I want to thank Susan Cooper for her donation to the city. It really is a very generous donation. Second point, I think we've talked about this, I think at the retreat, and given that we're now videotaping or videoing these meetings, I toss it out there to consider action minutes as opposed to regular minutes. For the sake of our city clerk, and I know she invests hours and hours writing those minutes, I think we've got the framework in place now that we should consider it.
Counselor Brown?
No report.
Counselor Wheel? Counselor Safadi?
First of all, I want to echo what you said. I think that's something that Councilor Gallagher mentioned about the meeting minutes and notes. And, you know, that's something we discussed, I think, a year or 2 years ago when we were talking about videoing and all that. And again, I'm all about efficiency and not wasting time and minimizing extra work, but, you know, there are pros and cons to both. But in any case, with regard, just one report, I want to thank our chief and Officer Pat that spent graciously 1 hour with me earlier this week and walked me through the proposed 2021 budget. And I always like when I sit with somebody that come up with a budget that they're looking at the money as if it's their own money. What is the best way to spend it? So I appreciate that. Thank you. And thank you for educating me on all the new good things that we need and what needs to be replaced. And so that's that. Thank you.
Councilor Sheldon?
Dan. Counselor Sheldon, do you have any comments?
Thank you, Mayor. Just two quick things. Number one, I want to point out our public utilities hard at work. I was pulling out of the Charlotte neighborhood yesterday, and instead of our utility companies pulling down the overhead power lines along Quincy, they were installing new poles and hooking up the old electricity and the old transformers and everything to brand new giant poles. So I called and notified our city staff, and they got them to stand down, but they just got their wires crossed, no pun intended, and they were putting in new poles when they should have been taking them down. But the second thing I did want to make mention again, if you haven't read the annual report, Jessica, I don't know if this is your handiwork, Jessica?
It is, yes.
Yeah, great job. I thought it was outstanding, as always. And Russell, your highlights that you put in the first pages, I think are spot on, and some really good things that the city has achieved. So congratulations to everybody. That's all. Thank you.
Thank you, Counselor Sheldon. City Manager.
Mr. Mayor, members of council, I do have just 3 quick items for you tonight. First of all, I want to introduce Paul Workman, who is here tonight. He is our new senior planner, and this is his first council meeting, second week. So he's got loads of experience, and I'll let him introduce himself quickly.
Good evening, Mr. Mayor and members of council. Testing. How about now? Does this one work? Does this one work?
Yeah, go, please.
Right or left, ma'am? No, it's I'm very excited to be here. As Chris mentioned, this is week number 2 for me, so I'm still kind of learning where the copier's at and where the pens are. But I'm very excited to be here. It's a great community, has a top-notch reputation in the metro area, and I look forward to working with you. I'm excited to be here. Thanks to Chris for the opportunity to join this organization. So thank you. Yeah. Short version is master's degree in urban and regional planning. I worked for the city of Commerce City for 9 years. I've spent the last 3.5 years at the town of Parker. In Parker, I oversaw their development review staff and processes. So about 12 years of experience doing community planning in a variety of development review, master plans, code updates, things of that nature. So I hope to bring some of that talent here and benefit the residents of the community.
Thank you and welcome.
Thank you.
Really-
The second item I have, last week, the executive committee for the I-25 Bellevue interchange met, and there is quite a bit of, Mr. Mayor, you may want to help me with the proper words here, a lot of teeth gnashing between Denver and the other paying members of the study, specifically related to how the public outreach is going to be presented. Some members of the team are wanting to present the conclusions of the technical analysis showing that the split diamond is favorable. And some other member, specifically Denver, wants to just leave that part out and just say, here are the results, here are the pros, and here are the cons. With all that said, though, Council, I do want to make you aware that we have been continuing to fight, and I am confident that we will get a Cherry Hills Village specific Zoom meeting after the regional Zoom meeting that will occur. I'm very happy about that. So that will be in mid-October. So once we get a confirmed date from the committee, I will make sure that we communicate that out. And then the last thing, Councilor Savavi mentioned that staff has begun to have some budget meetings with our liaisons. I do want to take that as an opportunity to indicate that I think as a result of perhaps the COVID impacts on property tax, the budget for next year is going to be more unknown maybe than in years past, simply because property taxes were delayed as a result, and we're not getting the final numbers on our normal schedule. And so we are having a little bit more of a making some judgments on what some of those numbers may be. And it may mean that some of our budget numbers are tight. And so some of the initial numbers that you may have had, we may need to go back and adjust them based on what we continue to get. With that said, I did want to clarify one thing now from earlier tonight in the study session, the 75th Anniversary Committee. That will be a part of the budget, and I think the Council's consideration of that specific element for the 2021 budget, that'll really be the final time that we'll be able to fully commit whatever resources we want to that committee. And so I think tonight was good, and they got a great feel for it, but it really will be that budget process where they get their final numbers. So I just want to make sure that was clear. That's all I have. I don't know if any directors have anything. Chief? No? Jessica?
Thank you. Just a brief report. As council knows, the Cherry Hills Village CARES program, Business Assistance Grant Program, is open. We still have not received any applications. I continue to try to reach out to the businesses, so we'll see if we get one before it closes in 30 days. And we can always extend that time period as well. We put 30 days in there, but it was staff's decision to put it at 30 days, so it can be extended. And like City Manager, sorry.
Habits die hard, I understand.
City Manager Kramer said the property tax numbers that we're getting from Arapahoe County have been delayed. I reached out to the county because we should have had those, at least a preliminary estimate by now, and was told because of some executive orders that were signed earlier this year because of COVID delaying the property tax payments, that has delayed their system as well. So they will not be providing us the preliminary numbers until October 13th, at least October 13th, which means by the time City Council gets the draft version that I'll have prepared for you on September 15th, and then we'll also have our study session to discuss the budget. So it'll be after that. So staff continues to work and see where we can cut back expenditures on a worst case scenario, and then it might be slightly different by the time you actually see it when we get those numbers from Arapahoe County on first reading. So just to give you a heads up.
And also related to the business assistance grants, we have heard that there are at least 2 that are intending to apply. We just haven't received those applications
Correct.
yet.
Thank you. That's very helpful. Emily?
Just to say we're putting the finishing touches on the park next door, and I'm excited to give council and PTRC a tour of the new park in 2 weeks. Thanks.
Jay?
We will be receiving bids back for the Highline Hampton footbridge to connect to the underpass on September 8th. We have had a lot of interest in that. I think we've toured the site with 8 or 10 different subcontractors. So we hope to get some good numbers back on those.
That's great. That's good news. And that construction would be what's time period are they looking at?
We hope to have everything ready so we can bring that to council for the the October meeting. And as soon as Hammond is out of the way, we'd like to start construction.
So maybe this year?
Yes.
City Attorney? Clerk? Laura? City Attorney?
Just real quick, Senate Bill 2217 wasn't the only law that passed in the legislative session this year. It was a very impactful one, obviously, but our firm's been monitoring the other legislation and preparing a summary with action items. And some notable items include some paid sick leave for employees and things that arose out of the COVID pandemic. And so we are working diligent. Some of that doesn't go into, some of it goes into effect now, some of it goes into effect in 2021, but we're working diligently to ensure compliance with all the new legislation is underway. So just wanted to let you know that.
Well, there's some medical leave things passed that may affect our budgets too, right? I don't know.
Well, the paid family medical leave is on the ballot, but yes, some paid sick leave in place now, and yes. So,
those could all
but,
affect Jessica's work too. So.
Yes, so we're working on that.
Anything else from anybody? All right.
I move to adjourn.
There's a second, and it's unanimous consent there. Without objection. Without objection. No objection. See everybody next time.